This is the status quo on the Joy News channel on your multi-TV networks. Let me introduce my guests who are with us tonight. First, we have Mr. Kwesi Danso Achampo. He's the immediate past deputy chairperson of the National Labour Commission, and today he's a labour consultant. Good evening, sir. Thanks for joining us.
Thank you.
And how are you doing this evening?
I'm fine.
Also with us this evening, Mr. Kofi Benton is a policy analyst with Imani. That's a think tank in town. Good evening, sir.
Good evening.
How are you doing this evening?
I am fine.
And Mr. Austin Game is a labour consultant and an ADR consultant. Thank you for being with us this evening.
Thank you.
So let me start with you, Mr. Danso Achampo. What's the mandate of the National Labour Commission?
The National Labour Commission's main mandate is to manage industrial relations in Ghana by resolving disputes that have arisen between employers and their employees, and also be proactive to ensure that the issues they are grappling with will not go overhand for them to result in strike action and other things. So basically, is to manage employer-employee relations.
It was set up in 2005.
Yes, the law came into force 13th March 2004, but the commission was set up in April 2005.
And since then, what's the commission been doing?
The commission has been working. There's a lot of work over there. Labor problems from the informal the sector, where you don't have much unions there. Ordinary employees are always complaining against their employers, so there's a lot of work there. Then, when it comes to dealing with the unionized staff and their employers, that is also another area where the commission is dealing with. So, the commission has performed quite well. The only problem we have is that, or the commission has had, is that the stakeholders, and when we're talking of stakeholders, we mean the employers, organized labor, and government. And industrial relations, when we're talking of government, we should understand not government as a political manager, but an employer who has employees and therefore he's dealing with. It's when we color it as government, they're introducing politics into it. And that is the difficulty that we face in resolving issues when they come up.
You say the Labour Commission has done quite well. I've been doing some research. In 2006, about 663 cases were referred to the Commission. About 28% of them were resolved in that year. About 71% of them were still outstanding by the end of the year. In 2007, for instance, about 686 cases were referred. 31% of them were referred, that's like 215 during that year. About 471, that's 68% were still outstanding by the end of the year. Certainly, that's not a commission that's been doing.
No, you see, the difficulty is that if you look at the setup of the commission and the way the law wanted it to operate, it has not been so. You are talking about 7 commissioners handling all these cases, and an attempt to delegate this function to other people. Now there's a case before the Supreme Court as to whether the commission can delegate some of its powers to subcommittees to deal with, And therefore, until that judgment is delivered by the Supreme Court to overturn the Court of Appeal decision, then it means that when you're talking of the commission, it's only the 7 people. And how can 7 people who are on part-time resolve all these issues that you're talking about?
But I thought earlier you were pretty confident that the commission had done fairly well.
No, that's what I'm saying, that looking at the circumstances the commission finds itself, they've done better. Because all of them, the commissioners are all part-timers. But we needed to sacrifice our own professions in order to be able to resolve that. Because we are supposed to meet only Wednesdays, and you have a pile, almost 10 cases coming to the commission per day, and you cannot delegate, as the Court of Appeal has held recently. Then you see that
So in other words, we've set up a body that's supposed to lead us in the management of labor issues, but the construction of that body is such that it doesn't allow the body to be able to actually deal with it. And that's why we're having these apologies.
I think so. And then also, you see, the powers of the commission. The lawmakers should really look at the law and make the Labour Commission a little stronger than it used to be today. Because if the parties that come before the commission know that they don't have the definitive power to make decisions, then their own trust and confidence in the commission is also down. Because after the commission has made a decision, it has to go to the High Court to enforce its decision. Now, there are two judgments by the high courts, two different high courts. One is saying that the decision of the commission, when it comes before it, all what they want to see is whether they've satisfied the requirements of the law. They will not go back into the merit as to why the commission arrived at that decision. In that situation, if the commission makes a decision, it's on you to appeal against it. If you don't, you cannot go back to the high court when the commission is going to enforce it to waste the commission's time. That was one decision by a high court. Another high court says, no, Labour Commission is an inferior tribunal, and therefore comes under the strict supervision of the high court. And therefore, we would like to go through the whole thing to see whether the commission has done the right thing. So with these conflicting decisions, when the commission makes a decision and makes an order, nobody is prepared to, implement it. They will wait. They will not even file an appeal against it. But when you go to the high court to enforce it, then they raise all the arsenals as to why the commission's decision.
And that's what's accounting for how well or yes, how badly the commission is faring so far.
No, in the eyes of the public, if the body that has been set up to deal with it hasn't got the power to make definitive pronouncement, then why will people come and waste their time there?
I'll come back to you, Mr. Champon, shortly, but let me come to my other guest. Do you buy this suggestion that these are the real challenges that, accounts for why the Labour Commission is not able to lead us effectively resolve or even proactively deal with this? Or you think maybe it's just a body that's just not working?
I don't think it's just about a body that's not working. Really, part of my problem with the people who lead institutions in Ghana is this. If you are supposed to do a job and you're not given what you need to do the job, don't do it. There is no point in establishing a body and half resourcing it so it can't do its job. Okay, so I hear the gentleman say, given what we have, we've done very well. In Ghana, we are all trying. When will we just get up and do what we ought to do? We took the pains, and there's a principle there. The principle comes from what he spoke about, government be an employer and government be a political body. Politicians, as of necessity, think in 4-year cycles. So as an employer, if you ask a politician to think, he's going to think in terms of what makes him win at the polls next 4 years. So the thinking was that let's take out some of these decisions from a political arena and put that decision in the hands of a body that can be independent, think professionally, and then determine these things. And we go through the whole meal and set it up. And then we fail to even finish properly setting it up. If I were asked to lead the Labour Commission, the first thing I will request is everything I need to win this war. So I can't say they are not doing anything, but I can't also say that, well, they are trying, because the point is, don't even start if there's no chance of you dealing with the situation.
Mr. Gama, the argument being made is that the legal construction of the Labour Commission doesn't even allow it to delegate. At least that's being challenged right now. Yes. It doesn't even allow it to delegate to some officials or experts to even help it out in its work. So, in essence, what we've done is to say, we want to deal with labour issues, we've created a body for it, but we've just ended up creating a toothless bulldog.
Yeah, to some extent, it's an unfortunate thing that has happened in this country. And it did not, and we shouldn't blame it on the Labour Commission, not even government. Unfortunately, it's the judicial system that created that problem. And again, fortunately...
But the judiciary didn't set up the committee.
But they are the cause of that problem. And I can tell you what it is. The law is very clear as to, when you go to section 141, as to how the commission can delegate its function to another committee, let's say the two of us, to handle specific issues and bring the result to the commission for it to be implemented. They went into this and created problem, and now you have information that 2 different courts have 2 different opinions on this issue. It shouldn't have been so. The law is unambiguous, very clear. The mistake came from the judiciary. Now, fortunately today, the Courts Interpretation Act is saying, among other things, that if there is an issue that will require some form of interpretation, they should endeavor to look for the information that went into, creating
the memoranda and other things that went along with the bill.
We generated over 2,000 pages of information and arriving at this law. So you can't just sit in a courtroom and then with an opinion, with maybe other old laws and come to a conclusion that that is not the same. So the problem is not from the commission. The problem is not a failure on the part of government and parliament that passed the law.
So you think the construction of the commission is right now?
It's very, the only small snag from the original thing that we put together was not to make the commission to be part-timers. They were supposed to be permanent people. Unfortunately, when Parliament was passing it in their wisdom, they made them part-timers because of maybe the creation of the mediators, arbitrators to be of support, and 141 to support them. Unfortunately, it's not being done the way we expect it to be.
None